All right, let's get started. I think, first of all, I want to say ArbTech is extremely privileged to be having Racheal Muldoon as our speaker this evening on questions of crypto regulation and what is happening in that space. And I wanted to say, just to clear the space, that when we invited Racheal several weeks ago, we didn't have a crystal ball and knew nothing about what was going to happen. But thank you, FTX, for imploding, because you are giving great currency to this event and this topic. And Racheal will be introduced by the moderator for this evening, who is my co-moderator on ArbTech, Sean McCarthy. He is an Irish barrister, he's a New York attorney, he's an international arbitration consultant and a former deputy counsel at the ICC Secretariat in Paris. He is a current ICC Young Arbitrator Representative for Ireland and a co-founder and moderator of ArbTech. I think it is fair to say that Sean is a blockchain fan and obsessed follower. He knows a lot about it, and not only that, but he knows how to make it accessible and understandable to the rest of us, and that is something that is very valuable for ArbTech to have. He is a long-time member of the Blockchain Ireland's legal working group, and he's to publish shortly a paper on digital assets, smart contracts, and blockchain-related GDPR issues for Ireland. He previously acted as legal consultant for a Swiss blockchain startup in 2017 and 2018. I am absolutely thrilled to be having this very topical conversation this evening. And Sean, please fire away.
Thank you very much, Sophie, for the very kind introduction. So yes, I'm just going to echo Sophie's welcome to Racheal. It's a pleasure to have her as our speaker for this evening's session. Just before we kick off, I'm just going to briefly outline Racheal's vast experience in this field and other fields, related fields. So Racheal is a barrister at the 36 Group based in Gray's Inn in London. While having a very broad commercial practice, a common theme within it concerns the sale, purchase and recovery of luxury high-value assets, ranging from cryptocurrencies to NFTs, to art and cultural antiquities. So Racheal also works in the area of financial regulation, in particular regarding digital assets, and was previously seconded to the UK's Financial Conduct Authority within the Enforcement, Oversight and Criminal Prosecution team. She was recently counsel in leading crypto asset related cases such as Deloya versus Persons Unknown and Osborne versus Persons Unknown. And this year she was ranked by Chambers and Partners for her crypto asset expertise. She advises clients in the above industries in both contentious and non-contentious matters, and thus her insights will be especially relevant as we talk through this evening's topic. Racheal, very welcome to you this evening.
I'm sorry. I forgot to say, and this is important, that because of recent instructions that she's received, Racheal is not going to comment on the FTX events. And really, as we were saying just before this started, this is not our topic, really. We have a much broader topic, which is about why regulators should look at crypto and how they are looking at it. And this is obviously very, very relevant in the FTX space, but not only. Thank you.
Great. Well, Sean,
exactly.
Sophie, ArbTech, I love the introduction.
Thank you very much, Racheal. So yeah, maybe I think it was a great segue by Sophie into the topic of regulation. And again, without going into any details, we've seen a lot of turbulence recently in the international crypto markets. We've seen a lot of increased scrutiny now coming back on governments about the fact that the centralized entities obviously were able to escape legal scrutiny and do what they did. So maybe to bring it back into the UK sphere, how are crypto exchanges, marketplaces, crypto service providers, how are they being regulated currently, especially in the UK?
Well, the framework is quite unique in the sense of some providers, that is exchanges and other crypto asset firms, those engaged in the space, some are regulated. So if we just move back a step then to crypto assets and their legal status before really looking at that delineation between who is regulated and who isn't, the FCA, being the UK's financial regulator, considers that crypto assets are essentially digital representations of value that exist on and utilize distributed ledger technology, so DLT. They can be transferred, stored, or traded electronically. Now, in practice, this is likely to cover cryptocurrencies using blockchain protocols, as well as non-fungible tokens, or NFTs. So in 2019, the UK Jurisdictions Task Force, the UKJT, declared in its legal statement that crypto assets can in principle be treated as property. And this was something that was relied upon by the claimant in the leading authority of AA and persons unknown in the High Court. And in fact, I was presenting yesterday with Matthew Green from Shoesmiths, who was the instructing solicitor in the case. And ultimately, they relied upon the UK Jurisdictions Task Force legal statement, saying there were compelling reasons for crypto assets to be considered property. And the court, in that instance, Mr. Justice Bryan, accepted those submissions. So AA is authority for the proposition that crypto assets in this jurisdiction are property. So that includes cryptocurrency, and thanks to somewhat bashfully my case of Osborne in March, that includes NFTs as well, at least at first instance. So moving on then to the regulatory position here in terms of crypto assets. This jurisdiction has, if I might say so, one of the most developed frameworks, regulatory frameworks, in terms of crypto assets in the world as it currently stands. Now, whether or not a crypto asset service provider is required to be regulated by the FCA in terms of having permissions under Part 4A of FISMA 2000, which is the statute in question, that really turns on one question. And that question is, looking at the token, what is that token trying to achieve? What does it convey to the holder? So we have four categories. We have security tokens. These amount to what we call specified investments. So they confer rights to the holder, security tokens, akin to a share, a debenture, something of that nature, as we know a security. The other form of regulated token is an e-money token. Now that's short and simple, just simply satisfies the criteria under the electronic money regulations, the EMRs. So if your token that you are looking to deal in as a crypto asset service provider, the FCA says a crypto asset marketplace or a crypto asset provider, if it is regulated, then you ultimately, in terms of dealing in it, offering it for investment purposes or custodial purposes for consumers, need to be regulated by the FCA or need to have a partner, an appointed representative who is regulated by the FCA. There are two other forms of tokens, so utility tokens. They grant you access to goods and services, so akin to a golf club membership, which don't offer benefits similar to a specified investment. That is unregulated, and activities in connection with it. And there's also exchange tokens, so what we would know as cryptocurrencies, such as Bitcoin, again, another form of unregulated category. So one needs to bear in mind that there is that clear delineation between tokens that are regulated and tokens that aren't, and then going a step further to say, well, how are you managing, how are you dealing in this token? Are you offering it for investment purposes, for instance? But then you have to go a step further and go, well, okay, even if I am only dealing in a utility token or an exchange token, and they are unregulated, it doesn't mean you're completely off scot-free, because since the 10th of January 2020, the FCA has also supervised firms carrying on crypto asset activity, even in respect of utility tokens and exchange tokens, which are unregulated, to prevent money laundering and also tackle terrorist financing. So there's supervision there. And that really, in a nutshell, Sean, is the framework here.
Great. I mean, a super overview of the UK position. Perhaps as a counterpoint to that, maybe talk us through your view of MiCA, the EU regulation or forthcoming regulation at least, and where do you see the UK going? Will they follow it? Will they not? And why or why not, I suppose?
Sure. So as we know, the MiCA regulation really came into the public limelight in, I think, September of 2020. And really that introduced proposals for what I would call wholesale reform of the regulatory landscape across the EU. So providing that really all kinds of tokens, be it e-money, be it utility tokens, asset reference tokens, which we'll come to know as stable coins, so tokens that are backed and pegged against commodities and currencies and other values. Really, it looks to establish a legal framework for consumer protection, and this is something that there are many proponents for, and I'm always a proponent for consumer protections. But when you step back and look at the policy objectives of those Rishi Sunak and others in this jurisdiction, it's very much provider focused. It's very much looking at how we can be a competitive jurisdiction for the market and for service providers. And as far as I see it, I can't see MiCA and the framework it stands for being rolled out here really true to other member states would, because it can be perceived as treading on the toes commercially of players in the market. Whereas if you look at, for instance, the Law Commission's consultation on digital assets, as we'll come on to speak about, there's very much reference throughout all 530 odd pages of maintaining commerciality and leaving decisions about how things are offered to an extent and how things are propositioned. For instance, not dictating that white papers be provided in a certain format or a certain way, whereas MiCA does go that far. So that's my kind of crystal ball gazing. I can't see us rolling out MiCA chapter and verse.
Sure, absolutely. And then maybe to switch back, you talked about the fact of the UK case law being, obviously common law being very flexible and very kind of forward looking and informed, it must be said, and the UK jurisdictional task force paper. So we've seen since then a UK Law Commission consultation paper. We've seen even a UNIDROIT working group, and we've seen a US ULC Emerging Technologies Committee that have all kind of looked at really the property law side of this kind of, if we want to call it regulation, but I suppose jurisprudence is probably a better word. And how have you seen this come about? And I'd love maybe first of all to maybe take us through the current landscape in the UK for case law and how digital assets have currently or up until now been treated.
Of course. So as I've said, the case of AA and persons unknown really was the beginning of the crypto asset case law in this jurisdiction. Mr. Justice Bryan said unequivocally that crypto assets constituted legal property. Now, he didn't specify the kind of property that with a categorization, and I'm sure we'll come on to shows in possession, shows in action, and anything more specific than that, save for, in that case, which concerned a ransomware payment in Bitcoin, the court was happy to step in and acknowledge that Bitcoin, being a form of cryptocurrency, being a crypto asset, could form the subject of a proprietary interim and final injunction. And this is something we've seen consistently from the courts in this jurisdiction. So following AA, we had Ion Science and persons unknown, shortly followed by Fetch AI and persons unknown. And then again, bashfully, several of my matters in which I appeared for the claimant. So Mr. Dollar Bill, Danitz, persons unknown, DeLawyer, persons unknown, Lavinia Osborne, persons unknown, and all the relevant exchanges in those cases. And what we're seeing consistently is the court stepping in to say, we will acknowledge that you have some form of personal property rights in a specified asset, being either Bitcoin or USDC, Tether, Circle, any form of cryptocurrency. And in the case of Osborne, in which I appeared for the claimant, you have personal proprietary rights in a non-fungible token, or in that case, two non-fungible tokens. So So as we'll come on to address, the Law Commission is examining all of this case law and looking at the jurisprudence, and both Racheal and Ober's comments and going, well, clearly the courts are seeing something here. Clearly the courts are standing up for the consumer and seeking to stem the bleeding and identify assets on the blockchain and freeze them and assert those rights, or rather acknowledge those rights. But what exactly are we doing from a legal perspective? How does this fit within the existing jurisprudence that we have? So I think the takeaway is an overwhelmingly helpful judiciary looking to do what's right and fair on balance, but not perhaps with the statutory footing and resolution of all these principles that's needed going into the future.
Absolutely, and I think, as you rightly say, the statutory footing, I suppose, ties their hands, the judiciary's hands, to a greater or lesser extent. And so this brings us nicely to the fact that the UK Law Commission paper has proposed a third form of property specifically for digital assets, what they're terming more precisely a data object. And perhaps you might kind of walk us through what they are considering, or firstly, maybe the characteristics of a data object, and then maybe what is and what isn't a data object for their purposes.
Of course. So we've looked at how kind of English law has carved out that crypto assets are some form of asset, not themselves an asset class. But you're right that the Law Commission really looks at, well, what is a digital asset? So I appreciate, I've been using the language of crypto asset because that is the language of the case law as derived from AA and persons unknown. And that encompasses both cryptocurrency and non-fungible tokens. But the Law Commission is very careful to say, well, look, just like the legal statement, the UK Jurisdictions Task Force legal statement, we don't want to confine ourselves here. We want to keep things broad. So the definition of digital asset that appears within the consultation paper is any asset that is represented digitally or electronically. And there are many different types of digital assets, not all of which will be capable of attracting personal property rights. So they keep it fairly broad, but with that slight caveat, I think, to afford discretion in future. But Sean, you said, what are the requisite characteristics then of a digital asset? Well, really, it's three characteristics. The first is that this digital item, this digital asset, has to be comprised of data which can be represented in an electronic medium. So I'll break that down. The second is it must exist independently of persons, and that's a funny one, I'll break that down. And the third is, and I can never say this word, it must be rivalrous. Bit of a strange word, and I must profess I did have to Google it when I first read the consultation. So if we look at the first then, it really comes down to you must be able to distinguish a digital asset from a thing in possession. So as I said, the law in this jurisdiction recognises two categories of property. It's either proprietary rights, it's either a thing in possession, a thing you can hold, an asset in the tangible sense, and a shows in action, a right you can enforce, so akin to a debt that you can enforce. Now, a data object, in the way we've described it, as a way as defined in the paper, doesn't fall into either of those neatly, and that causes a whole host of problems, not the least for courses of action such as conversion. So this first characteristic, it must be capable of being represented in an electronic medium. So this will include in a form of computer code, electronically digital analog signals, and it's distinguishing it from a database or something that's capable of being stored on a server, for instance, and held in a tangible way, bizarrely enough. That's the kind of distinction that's being made. Now, the second strange feature is it must be independent of persons. So it must be separate from, almost akin to, it must be not a severed hand, that's the comparison made, but it must be capable of being separated from a human being, and therefore not not being shows in possession in the standard sense. It's a bit of an odd one, and always the comparison's made with a hand connected to the body rather than a severed hand. And I'm not entirely sure whether that came from Jeremy Bentham or something else, but that's the second category. And the third, this rivalrousness, is that a thing must, a digital asset can be consumed by no more than one person at any given time. So it's all these demarcations and really setting out the limits of what this digital asset is, while proposing that in future this will of course be subject to change, so it must be broad.
Absolutely great. Yeah, no, I think for sure the rivalrousness also was something a bit traditional and something straight out of the 18th century, like something you'd see in a Charles Dickens novel. But I absolutely agree with you. I think this whole idea of this is really breaking new ground, and the Law Commission, I think, are very, very careful not to overplay their hand, as it were, and fall into the trap of maybe making some kind of pure informational or digital information be seen as some kind of digital asset, which they definitely do not want it to be. Maybe then as a kind of follow on from that classification as a third type of property, the UK Law Commission then thought about, well, when we talk about things in possession is obviously a very important legal principle, and they've proposed a, shall we say, kind of a hybrid method of characterizing possession, and they call it control. So perhaps take us through what the UK Law Commission has proposed in terms of control of a digital asset.
Of course. I'm a massive advocate for this, in the sense of, well, in the conventional sense of things, the shows in possession can of course be held and possessed. Can you possess a token in your crypto wallet? It's a little bit tricky to say, and yet this is a concept we're familiar with possession, particularly in the context of granting urgent interim relief and having all those principles in place. So really, the person that happens to have or hold an object at any particular moment in time in the law is considered the legal owner. Well, subject to legal title passing, but that's the baseline. So what the consultation proposes is more so a control-based principle, whereby a data object can be controlled by the custodian of a wallet. If there's also potentially access and control by a provider, such as an exchange, and that is borne out, of course, by the case law, where we've seen exchanges subject to injunctions and those injunctions and worldwide freezing orders providing for the freezing of assets. So in that sense, we're not confined to the concept of possession. So it may be that there are multiple people who have control over the asset in those circumstances. And is also something I've come across in my experience as well. The crypto asset marketplace doesn't, of course, have possession or even to a point custody of a crypto asset, and yet they are listing the asset for auction. So in the conventional sense of the law, we would deem that a bailment scenario. And yet, can you have bailment of an intangible data object? Well, again, it's something that hasn't been tested, but as a matter of principle, why should a digital auction of a data object be any different from a digital auction of a tangible? So it's something that the law will have to grapple with, but I do support a control-based system, a control-based principle, as opposed to possession, because of the nature of the asset.
Racheal, I was wondering, I'm sorry, Sean, for butting in, but I was wondering for our audience who are not au fait with the intricate, arcane English law concepts of bailment, maybe you would want to just explain very quickly what that means.
Of course. So you have two parties. You have a bailor and a bailee, and the quintessential example is where you consign a good to an auction house for sale. So it's something I've advised some of the largest auction houses in the world. But no matter what the size of the auction house, you have a contractual relationship whereby you have consignment of a good. So take, for instance, an oil painting, an old master, from a bailor to the auction house, who acts as agent essentially for the sale of that asset. So they take possession of it, and many auction houses will have storage units and things of that nature with climate controls and security, as you'd imagine. And it's the concept of taking custody of that asset for a particular purpose pending its sale. So it's that kind of relationship whereby the parties enter into a contract, there's a consignment of a good for a specific purpose for a period of time where there's that understanding that one will act as agent for the other. And in the same sense, what are you doing when you're depositing cryptocurrency or a non-fungible token with a certain platform provider? Well, in any port, anyone would recognize that it's for a specified purpose. So with an exchange, it's depositing crypto and potentially exchanging it into another form of cryptocurrency. But it all comes down to control from a custodial point of view. There's custody. And this is what case law will examine in great detail in the coming months and years. Is there a bailment type relationship, an agency? Are there fiduciary duties, trustee duties flowing? Well, exactly.
That's what Tulip Trading examined, right? And that the threshold for that is very high. Tulip Trading being a case that is going to the Court of Appeal, as I understand it, as well.
Yes, and it's as we know, without naming names, it's looking at just the baseline of what is the platform doing. So you look at the terms of use of many of the exchanges, and they either fall down one side or the other. It's either we do not take custody of your asset, we have no control over it. Okay, we accept we provide you with a wallet, and we accept that we take fees, certain fees for various things. But in terms of the services we're offering you, they're by no means custodial, we're by no means managing. Well, it begs the question, what are you doing?
Yeah, exactly. You can't have it both ways. Yeah.
Well, exactly. And meanwhile, the other exchanges, and you don't fall into that camp, throw their hands up and saying, well, we do have custody. And then again, that begs the question, well, okay, in the conventional sense, then how are you securing those assets from a computer misuse threat point of view, from a segregation of funds point of view, from a liquidity point of view, the fiduciary duties? So it's going to be a fascinating few years, and that's why this consultation from the Law Commission is timely, because it's a perfect moment to take stock and go, well, how can we future-proof, or at least start that process of enhancing this jurisdiction as one of the best, if not the best in the world, to be a consumer of crypto assets.
Absolutely. So we have a question here from an ArbTech community member and a very active one at that, Andre Cardoso, who says, when it comes to decentralized exchanges that are based solely on smart contracts in a specific blockchain network, how do you think we should define the idea of custody? And is it possible to pursue the possession, or custody of some digital asset?
Right. Okay. Well, it would be, of course, very fact specific. But as you say, if there is a controlled environment in which assets are deposited by users associated with a particular exchange, then in the first instance, it would come down to the terms of use, as I say. What are the services they're actually providing here? What are the parameters? And does that stand to reason? Does that stand to the correspondence, promotion, the activities actually undertaken in regards to the user? And if not, well, clearly they're incompatible with the terms of use. So it will come down to really the exchange's justification for taking fees in any given case, and also their subsequent actions. If an action is brought and interim relief is secured for two things, but in particular for an interim proprietary injunction, and the claimant is able to point to Bitcoin, for instance, in a particular wallet associated with an account on the exchange and say, that is my property, and the court is willing to uphold those personal property rights, and the exchange turns around and says, we will comply, well, by implication, they can exercise control over the crypto assets on that platform. If, on the other hand, they turn around and say, well, we can absolutely do nothing to assist you, well, again, that does beg the question, are you allowing your platform to be used as a vehicle for fraud potentially? And that also leads me on to the second point, which is if the exchange is compelled to disclose KYC and other identifying information under a disclosure order, which as a matter of course, us practitioners will nearly always apply for alongside interim relief, then if you're not able to divulge anything, if you simply turn around to an exchange and say, we have nothing associated with the use of the account holder, the custodian of this wallet, then again, doesn't that beg the question, well, how are you preventing, how are you exercising due diligence as to who is interacting with this platform and using it potentially for nefarious purposes? So it's crunch time for exchanges and other participants in the marketplace, because they are coming under intense oversight and focus from the regulators, lawmakers, in light of recent events.
Absolutely. And so maybe to kind of look into the future a little bit, and I suppose to build upon what the UK Law Commission are, well, they haven't proposed either one way or the other, either to have codified regulation for this new form of property and new characterization of control. They haven't proposed that, or they haven't advocated for just a common law, case law first approach. But where do you see, first of all, where do you see the drawbacks of either approach being, and then how do you think the I suppose these principles will continue to develop in the next few years?
Sure,
at least in the UK.
Yes. Well, certainly I can see how attractive it is to say, well, look, we have a common law legal system here. It's served us well in that there is that flexibility and the law can develop organically. And I'm convinced it's put us in a very competitive position because, of course, in codified legal systems, you don't have that flex to adapt to new technologies. But really, we are hitting that crunch point now, as I find myself when I'm drafting legal submissions in my ongoing matters, one of which is the first contested crypto asset recovery matter, that you have to be creative within the realm of the law as it currently stands. And there are fundamental inconsistencies. So, for instance, a crypto asset or digital object or data object, however you want to define essentially crypto assets, what we're talking about, don't qualify as goods under the Sale of Goods Act. And that's something that's examined by the Law Commission. Well, how can that be right when a good chunk of the case law is examining and will go on to examine consumer rights attached to these assets, and trustees and family offices, for instance, really looking at diversifying funds and structuring funds to cater for crypto assets, and something I advise on, when in fact, how do consumer rights flow when we're not even dealing with goods? It's or a service as it's currently defined. So it's a bit of an awkward position at the moment. How do I see it developing? I have complete faith in the courts in this jurisdiction and the judiciary. Even though I was somewhat misquoted in the FT as as calling the judges in this space old and dusty, which I certainly wouldn't have said. They're by no means that. They're very much willing to get their head around the concept of the blockchain of DLT, of last hop and intermediary wallets, and all forking, staking, you name it, and all the language that comes with this space. I have faith in the courts because, of course, legislative change takes time. And this is a very, very fast moving space, isn't it, Sean?
Absolutely,
I mean, we have
yes.
a question from James Rowland, which Sean will address. I just wanted to butt in again. I'm being very rude, but
No, please,
no problem, Sophie.
Not at all.
No, but I just wanted to ask you, Racheal. I obviously, as a barrister, you would have faith in the judiciary in this country that has shown itself to be historically extremely responsive and adaptable to change. I mean, we have a technology and construction court. We have. Are you seeing the knowledge in the English judges? I mean, this is a very new and, as you said, extremely fast evolving. Are you seeing the equivalent of what Dubai is doing with their digital economy court sprouting through the English judiciary?
Very good question, Sophie. Let's face it, Dubai is really showing us the way, isn't it, in terms of a coordinated response. And it's been well publicized, and we have the digital asset
And we have
Michael
Black-Casey at the helm of it as well.
Exactly,
yes.
Right. So I think what Dubai is doing is fantastic, and increasingly Singapore, where last week I was speaking at another conference, and it's just fascinating what's happening there as well, and the case law developing. Well, look, I think what I've seen here is a real foundation of knowledge. I think we don't always see it, but I'm sure individual judges, particularly in the interims lists, are at the very least speaking to one another and sharing their experience of what are real nuanced concepts, particularly of the blockchain. And I wouldn't be surprised if there was training going on behind the scenes, because it's very rare that I go before a judge in these lists and they're not familiar with any of the concepts. Now, I'm very happy to, as I have for many hours, stand on my feet and address the key principles and cite the experts' reports in support of that. But I am seeing really, Sophie, a concerted effort from the judges here to educate themselves on this new and emerging relatively new and emerging technology. So yeah, particularly in the field of NFTs and the metaverse, it's fascinating, really is.
That's fantastic. Sorry, Sean, sorry.
I'm going to try to just stay off.
No, please do.
No. We're always happy for your interventions, Sophie. Thank you. So yeah, we have a question from James Rowland here. It goes back to the previous point we were talking about in relation to, will it be a common law led approach or a potentially a codified law approach? He asks, when will the Law Commission's recommendations become law? For the purpose of criminal law, the definition of a new kind of property has to precede the crime against that property. And I suppose it's a very valid point that he makes, in that there will probably need to be some, I suppose, legislative footing for some of these defined terms, or however you want to put it, so that, I mean, we can't. And Sophie made the good point in a question that she asked at the start, where we're seeing these cases that are just against defendants who are persons unknown. We're obviously only scratching the surface in some ways in some of these cases in relation to developing new principles, new ideas. So do you see the need potentially for, especially say, consumer protection into the criminal law field? Are we going to have to see some legislative footing being implemented?
Yeah, no, I definitely take the point. And as a former criminal barrister as well, and we were discussing my first Crown Court in the Bailey, weren't we, Sean? I think there will be that need for a framework in legislation. So especially looking at the service providers. So the best we have at the moment is if you go on the FCA's website and you go onto the crypto asset page, it will break down and have mind maps of essentially, yes, no, okay, let's go up there, and okay, maybe I will need regulation. And there is talk of the services provided by a crypto asset firm, but I can see there being a legislative underpinning for, are you a wallet provider? What does that look like? Are you providing investment services in that kind of ecosystem? Is it outside that ecosystem? And apportioning liability according to your activity. But if we look at, for instance, legislation that's coming into the fore, so you have, I think it's the Economic Crime Bill, is it? Looking at the rights potentially for magistrates to order essentially the delivery up of cryptocurrency. Now, quite how that's going to work in actual fact is very difficult indeed, because as we know, if you're going to deal in or access a crypto asset, you need the private key for the wallet in which it's held. In most instances, there are some exceptions where you can approach the cryptocurrency, say Tether or provider, and have the token destroyed or otherwise. But it'll be interesting to see how legislation seeks to, as we say, define it broadly enough to encompass the technology it develops in time, but also specific enough that it could form the foundations of a criminal prosecution without any uncertainty, or underpin a consumer rights class action, for instance. So there will invariably be that legislative change within the next 3 to 5 years. But I'm just doubtful as to whether we can move quickly enough to address the real pressing need, particularly for consumer rights, particularly for governance and compliance based responsibilities and fiduciary duties of the service providers in this space. Because as we've seen, without naming names, the fundamental need to segregate funds in the absence of compensation schemes, as we see in centralized finance models, it's so pressing that I'm afraid I don't think we can wait for readings in the chambers and bills and drafting. This is a matter of months, not years.
Sure, and I think even the UK Law Commission themselves in the consultation paper, I think, admitted that the difficulty, especially, I think it was the Electronic Trade Documents Bill, how difficult technically it was to really bring that piece of legislation to a place where it could come into practice. So I think absolutely you're right. It's not necessarily you can't create a panacea and it will cure everything. It has to be done kind of piecemeal here and there, and we'll have to continue to evolve along with the case law, I suppose. Sophie, please go ahead.
Racheal, would you agree? I mean, in the many talks that I deliver on the topic of legal tech and dispute resolution, one of the very important things that underpin these talks is the notion of time.
Yeah.
And I wonder, I mean, I see time as completely compressed in the Web3 economy, which has immediate, practical, procedural consequences for dispute resolution. Would you agree with me, or would you say that I'm just being, facetious?
No. By compressed, what do you mean, Sophie?
I mean, everything is immediate, right? So when you are talking about dispute resolution on chain, you need to think about something that is, if not immediate, because you cannot have immediate decisions, but at least have a timeline that is reduced, as opposed to what we know in the courts. And I wonder as well, we were talking about the English courts just earlier on, I wonder whether the English courts are also aware of that in those disputes, that there needs to be as quickly a dispute resolution as you can have.
Yes, no, absolutely right, Sophie. When I advance applications for interim injunctions and worldwide freezing orders, the fundamental aspect of that is urgency. And I think it's really captured by and forgive me with the cold brain, but I believe it was Ion Science and Persons Unknown. So Mr. Justice Butcher, in that case, in the context of examining whether to grant a banker's trust disclosure order, did say Obiter that crypto assets can be moved at the click of a mouse. And so that's the immediacy, that's the need to stem the bleeding now. And as a practitioner in this space and someone who's been doing it for nearly 2 years now, I can say from first-hand experience, I've been on my feet, with the blockchain entry looking to my left, and I've seen that the asset in question, which is forming the subject matter of the relief, has moved. And I'm having to say to the judge, quick, I'm amending my application now. You can click on the link in the expert report and see in real time that, looking at Etherscan or wherever, that the asset has moved. And so
and how responsive are they to that?
Oh, very, very, very responsive. I think, to be honest, it's quite shocked for those who are new to this space. Obviously, not the big hitters in the commercial court, but certainly in the Chancery Court and the now KBD, they do appreciate that. My goodness, that this really is immediate, and we don't perhaps have the responsible parties that you have otherwise in a centralized model,
Yes.
that you can rely on to do the right thing here. And I say the right thing from obviously a fairness, a personal, a proprietary rights point of view, upholding the claimant's rights to their assets if it's proprietary. And also, I would go so far as to say act in good faith, because to act in good faith, you need to have that commercial awareness, don't you? You can't exercise Nelsonian knowledge and close a blind eye to the obvious here, which is if you're not exercising due diligence, if you're ignoring court orders, if you're really not engaged with how it is you have custody of an asset, or segregate it, or ensure liquidity in the system that you're operating, the platform, how are you preventing your platform from being used as a vehicle for fraud? How are you engaging with compliance and governance? Well, you're just simply not. And as a result, you're exposing yourself, your platform, and your directors' personal liability to liability. So it's quite scary, isn't it?
I mean, can I just, sorry, Sean, I'm just,
No, Sophie, please,
I was just going to take Racheal onto my pet topic of due process, because in a very restricted timeline of dispute resolution, we can't wait 30 days for people to file things. How do you see due process surviving in a streamlined way? Are the courts responsive to that?
Yes, no, there is definitely room for improvement. At the moment, they're responsive in the sense of urgent application, ex parte, without notice, in secret, secure that relief. And in submissions, we'll say, look, we need to serve this overseas. It might be in Seychelles, Cayman, BVI, Singapore, you name it. And the courts are very willing and happy to assist, as I've said, in terms of granting those permissions. And they'll grant permission for service by email as opposed to postal to expedite matters. And then, of course, when you say, well, I want the return date in this matter within 10 days, there's no raised eyebrows if there has been provision for that alternative service. And then, of course, you're looking for default judgment if they don't engage. And I do get a real sense that the court is alert to the need to expedite proceedings. But I do think certainly going forwards, and also from an arbitral proceedings point of view, there needs to be, as you say, an appreciation for the need for immediacy, stem the bleeding, and once the assets are secured and you have it on good authority from the relevant exchanges they are secured, yes, then make sure that the timeline doesn't follow the conventional months, years, it's days, weeks.
Thank you. Thank you.
My pleasure.
Sean, you're...
Thank you very much, Sophie. No, I mean, great questions, and I think it's definitely, I have the same kind of questions as Sophie, really, in my own mind, because obviously we see you much more so as a litigation practitioner in this field, and the two of us being much more so in the arbitration sphere. So it's great to see the contrast and what your valuable insight is. And perhaps maybe to kind of round off the session and let you get back to your sick bed, NFTs. Obviously,
Yes.
you've done a lot of NFT related cases. Maybe speak a little bit, if you can, about what the Law Commission paper has said about NFTs, and maybe a flavor of what you're seeing in your practice.
Yes, no, absolutely. So the Law Commission touches upon NFTs. They do say that NFTs, non-fungible tokens, as another form of crypto asset alongside cryptocurrency, they do raise similar issues in the sense of how are we conceptualizing them as legal property, and how are personal property rights derived from them? Are they shows in action, shows in possession? Well, no, they should fall under this third category. But they do go a step further and show a real appreciation for what an NFT is capable of. What is the utility of an NFT? So it can act as evidence of legal title, although I don't like the language of a digital receipt, because that's just not fair to the utility of the asset. It can embody intangible rights, it can package rights, and in that sense be a legal structuring tool. So what the Law Commission really look at is, well, how is the law going to grapple with a token which they say should be an asset in and of its own right, a non-fungible token, which I'm pleased to say was the finding at first instance in Osborne and Persons Unknown, where I appeared for Lavinia Osborne in March. It should be an asset in and of its own right, but it has this relationship with something else. And that something else is the asset, be it tangible or intangible, that the token represents. And as you say, there is this legal structure whereby under the smart contract, hopefully there is provision for that relationship. What rights are derived from that token that entitle you to something potentially to do with that underlying asset? So I think the Law Commission show a real insight into that. And interestingly, they call for potentially a crypto asset register, or a crypto token based register is how they put it, whereby legislation could set out that there is a register of the rights which an NFT grants you. So for instance, an NFT representing that oil painting, the Old Master, which doesn't entitle you to ownership of the Old Master, the other asset, the underlying asset, but you might be able to go visit it in a manor house once a year for the remainder of your life. And that is the right that the NFT, you being the holder, conveys to you. So I think the Law Commission show real insight, and it's something that I had to drive home in my submissions in Osborne, saying to the judge, well, look, my client one day had these 2 NFTs in her wallet, and then the next they vanished. Now, she has personal property rights in those 2 NFTs. They both represent digital artworks, and she has some rights, limited rights, potentially from an IP point, to those underlying digital artworks. But it's showing that awareness, because consistently we see, and it's a real bugbear of mine, misinformation about non-fungible tokens, the misnomers of NFT art. There's no such thing. It's just like crypto fraud. We don't use the terminology cash fraud, do we? It's simply fraud. So when you hear the term NFT art, well, one can assume that it's an NFT, a token that represents a flat artwork, tangible, or digital artwork. So it's dispelling these myths and really getting down to the basics of an NFT's utility to package rights. And the courts are very much aware of this, because in Deloyer and Persons Unknown, where I appeared first instance for the claimant, and it's an ongoing matter, certainly in June we obtained judgment for Mr. Justice Trower, and we, for the first time in this jurisdiction, obtained permission to serve legal proceedings on the Persons Unknown by NFT. So that doesn't show the utility of an NFT to capture, to represent legal papers, then I don't know what does.
That's amazing. And maybe Racheal, maybe just take us through a little bit how that came about, and what was the kind of the judge's approach to it, and then I suppose from an enforcement point of view, then I mean, how did you actually go ahead and practically get that done?
Yeah, no, of course. So it was born out of necessity. So certainly I've had other cases since like this. But essentially, when you have these kinds of mis-selling of crypto assets, or really a fraudulent investment platform, where you have a claimant who is approached, typically on WhatsApp, socially engineered, coerced over time, or induced rather, to transfer their Bitcoin, for instance, into a wallet, under the understanding that in fact they're transferring it to a legitimate brokerage that will generate profits for them, which they'll, benefit massively from, when in fact they transfer it into the wallet, and pretty much from day one, that Bitcoin is transferred on. It's not invested on their behalf, trades aren't placed, and it's all just, unfortunately, a fictitious fraud. And so in those instances, what do we have? Well, we might have some contact details, you might have email addresses, you might have a WhatsApp number for the persons unknown who've coordinated this fraud. But what happens if that WhatsApp number ceases to be active, which is often the case? And what happens if the website that was used as a vehicle for fraud goes down, which again, sadly, is often the case? And then also if the emails are no longer responsive. Well, in conventional terms in the past, that's the end of the matter. You can't serve proceedings on the persons unknown, that's it. And then, funny enough, I think it was 8 days before Deloya, the first hearing in Deloya, LCX was heard in New York State, and the court granted for the first time in the world permission to serve proceedings by NFT. And so they just picked us to the post, but it's only fair we give the other side of the pond a bit of a head start every now and again. But so 8 days later, we decided, well, look, let's see if we can do the same here. And I presented it to the court in accordance with the judgment as there is no other alternative. In this instance, for this particular defendant, we have every reason to believe that the contact details aren't active. And so how on earth do we put them on notice? So the metrics of it, as I say, is an NFT is a token that represents something and points to something, using your artwork and token example, and conveys rights under the smart contract that governs that relationship, but query whether it actually has that smart contract, the smart legal contract, been drafted particularly effectively. That's something I advise on for ICOs and NFT drops. But really what we need to do there is you are getting the legal documentation essentially in PDF format. You are then minting an NFT. Typically that NFT will contain, or embedded within, will be a unique reference link, a URL, that will essentially, like a cloud-based platform, direct the recipient to a central repository of documents, and either in redacted or unredacted form, depending on the permissions you obtain from the court. And it's as simple as that, really. So it's no different from a URL to a cloud-based central document repository appearing in an email. The only difference is, and I rather love this, is that we're utilizing the wallet that the persons unknown gave, or the wallets into which the misappropriated crypto assets were deposited, which essentially all act as a vehicle for fraud, to serve legal proceedings on the persons unknown. I think there's a certain sense of justice about that, which appeals to me rather.
Absolutely. I think it's as you said, the whole rights element of the NFT. The other side of the coin is obviously the obligations that are created around the use of digital assets, and this is the perfect way, as you say, that it's their unique fingerprint, these wallets that are used, and why not use NFTs to send it to that wallet and
Exactly.
And put them on notice. It's great. Sophie, I think we're probably ready to wrap up the session, so I'm going to leave you the great honor of
and a great honor it is indeed. Racheal, I wanted to really thank you for being insightful and understandable, because that's not an obvious thing we're finding out in ArbTech in this field, to make these questions palatable and understandable to a wider audience, and it's important that they are. I thank you for being here in a not so great physical state, and I hope you get better. I just wanted to say, I think these are questions that are going to be at the forefront of the legal field and the regulatory field going forward. And it's great that the UK is taking a stand that is forward-looking. We at ArbTech are very much interested in whatever goes forward after this. And so we hope to have you again telling us what the developments will be going forward. Thank you. Thank you everyone for being here. This will be disseminated on our social media and on our website. Thanks, Racheal.
My pleasure.
Thank you very much, Racheal. Bye.
Evening, everyone. See you. Bye-bye.